Core Module 1, Crime. The nature of crime. The meaning of crime. An act or omission committed against the community that is punishable by the state. The elements of a crime. Actus reus, guilty act. Physical act of the crime. Mens rea, guilty mind, the intention to commit the crime. Strict liability offences are offences that only require proof of actus reus, that it was a guilty act. Causation. Actions that result in a crime without intention. So there are many different categories of crime. There are offences against the person, which include homicide and assault, offences against the sovereign, which include treason and sedition, economic offences, which include property offences, white-collar crimes and computer crimes, drug offences, drinking offences, public order offences, which include affray and riot, and preliminary crimes, which include attempt and conspiracy. So on to summary and indictable offences. An indictable offence is a more serious offence. An example is murder, which is tried by a jury and a judge, and the charge is brought by a public prosecutor working for the state. A summary offence is a less severe offence, and is tried by a magistrate in a local court. There is no jury, and the charge is usually led by a police or government officer. So there are several different ways a person can be involved in a crime. They can be a principal in the first degree, which means that they are directly responsible for the crime, principal in the second degree, which means that they encouraged or assist the offender in the crime, an accessory before the fact, which means that they were involved in planning the crime, and an accessory after the fact, which means that they assisted the offender after the crime has been committed. There are many different factors that can affect a person enough so that they commit a crime. These factors can be psychological, pathological, or due to self-interest, or due to social, economic, or political differences. Other factors may include low academic achievement, unstable relationships, peer pressure, or mental illness. Crime prevention is a better alternative to crime reaction. This is because people don't seem to learn from their actions, and statistics show that people in jail are more likely to commit a crime when they get out of prison. Crime prevention addresses the issue of crime, and it is safer for society. It's also cheaper in the long run and brings the community together. The criminal investigation process. Police investigate crimes, interrogate suspects, make arrests, and gather evidence. The police are obliged to use reasonable force, and if they were to make an arrest, they must have a legitimate reason. Reporting a crime. People would be reluctant to report a crime because they either do not want to be a part of the crime, they have already dealt with the crime, or they are ashamed or embarrassed, especially with sexual assault victims. Investigating crime. Gathering evidence. Gathering evidence is under the Evidence Act 1995, New South Wales. The use of technology must be reliable in court. Search and seizure. Police may search and seize objects under the Law Enforcement Powers and Responsibilities Act 2002, New South Wales. Use of warrants. Legal documents signed by a judge or magistrate which allows a police officer to perform a certain task. Example, arrest or search. Arrest and charge, summons, warrants. Arrest is one of the most important steps in the criminal trial process. Charge. After a certain amount of detaining a suspect, police must charge or release the suspect. Summons is a legal document stating when a person has to be in court. And we've already been over warrant, so I don't need to repeat that again. Bail or remand. Bail is the decision to let the person free before their trial, and remand keeps a person in custody until their trial. Detention and interrogation. Rights of the suspect. The suspect being interrogated is only allowed to be detained for 4 hours. The suspect is informed of their rights before they are interrogated, and they have the right to legal representation. Criminal trial process. Court jurisdiction. Under the Judiciary Act 1903, Commonwealth, a state or territory court has the power to hear federal criminal offences. The authority for a court to hear a matter for the first time is called the original jurisdiction, and the authority to review a matter on appeal from another court is called the appellate jurisdiction. The adversary system is a system where two opponent sides present their case to an impartial judge. The advantages of this is that each side is less prone to abuse and bias from the official determining the case. It allows each party equal opportunity to present their case, and there is an impartial jury. The disadvantages in the adversary system are competing sides are not equal before the law, and there are potential imbalances in resources, skills, or knowledge, and the jury may have a hard time understanding the technical jargon in some cases. There are four main different types of legal personnel. There's the magistrate or the judge, which reviews the case and gives a sentence, the police prosecutor, which gathers evidence against the accused and represents the state, the director of public prosecution, which prosecutes against the accused in a criminal trial, and the public defenders, a public barrister who can appear for an accused in serious criminal matters where legal aid has been granted. Pleas and charge negotiations is where the defendant bargains with the judge for bail, or in post-sentencing a lesser sentence, going up for appeal. The defendant has a right to a fair trial and a right to legal representation. A lack of legal representation was shown in the case Dietrich versus the Queen, where the defendant had to represent himself. In 1979, the New South Wales government created the Legal Aid Commission under the Legal Aid Commission Act 1979, New South Wales. The LAC, or the Legal Aid Commission, provides free, brief legal advice to anyone. Burden and standard of proof. Standard of proof is the notion that a person is innocent until proven guilty, and burden of proof means that the prosecution have to prove that the accused actually committed the crime. Use of evidence, including witnesses. Evidence cannot be tampered with, or else it cannot be used in the court. A witness must tell the truth when they are in court. Now, there are two different types of defenses to criminal charges. There's complete and partial defenses. Complete defenses justifies the defendant's actions, and a partial defense means that the defendant may have been provoked to commit the crime. The role of juries, including verdicts. A jury decides on the verdict, guilty or not guilty. If they cannot come to a decision, it is called a hung jury, and the case is started again with a different jury. Under the Jury Amendments Verdicts Act 2006, the unanimous vote was scrapped, where all 12 jurors had to agree, and now the vote can be 11-1. There are many reasons for and against a jury in the criminal justice system, and the reasons are as follows. Well, you can just read them, I'm not going to say them, so yeah. Sentencing and punishment. Statutory and judicial guidelines. These are guidelines and laws set to determine what sentences are given, and this is under the Crimes Sentencing Procedure Act 1999, New South Wales. The purposes of punishment. These include deterrence, which discourages someone from committing a crime; retribution, which is a punishment that is considered morally right or deserved based on the nature of the crime; rehabilitation, which is the opposite of prison and is designed to reform the offender to prevent them from future crime; and incapacitation, which restricts the offender's freedom, prison time. Factors affecting the sentencing decision. These factors are aggravating and mitigating circumstances. Mitigating circumstances lessen the sentence, and aggravating circumstances increase the sentence. A case that uses aggravating and mitigating circumstances is the case McCartney versus the Queen 2009, which is a sexual assault case. And mitigating circumstances were taken into account. The fact that both of the characters were intoxicated and the defendant was an alright guy, apart from the fact that he was drunk and sexually assaulted the victim. Yeah. Anyway, the role of the victim in sentencing. A victim can become involved in the criminal process, and this is under the Victims' Rights Act 1996, New South Wales. They are able to write a victim impact statement, which is an aggravating circumstance in court. Appeals. Appeals are made to a higher court against a conviction or sentence. This is under the Crimes Appeal and Review Act 2001, New South Wales. These people aren't really good with imaginative titles to their legislation. A case includes AEM Senior versus the Queen, KEM versus the Queen, and Double M versus the Queen, 2002, which is another sexual assault case. The lenient sentences given were taken to appeal because the public did not agree with the leniency of these sentences. Types of penalties. These include no conviction recorded, a caution or a formal warning, a fine, a bond, suspended sentence, probation, criminal infringement notice, sort of like a fine, penalty units, community service order, home detention, periodic detention, forfeiture of assets, imprisonment, which is the most severe and a last resort according to the Crimes Sentencing Procedure Act 1999, New South Wales, diversionary programs, which are alternatives to traditional court and is therapeutic justice and rehabilitation. And that's it. Alternative methods to sentencing. This includes circle sentencing, which is a way of addressing things about different cultures only for summary offences, and is also a way of addressing issues about the Aboriginal community. And there's also restorative justice, where the offender faces the victim's family, and the offender must have remorse for restorative justice to work. Post-sentencing considerations. Security classifications. Minimum or maximum security. Protective custody. Correctional authorities have a duty of care over the offender. Parole. Conditional release of a prisoner after the minimum term is completed. Preventative and continued detention. Preventative is the most controversial and most harsh form of detention, and continued means that the offender stays in prison after their time. Sexual offenders registration. Established under the Child Protection Offenders Registration Act 2000, New South Wales. Deportation. Under the Migration Act 1958, Commonwealth, a migrant can be deported if they are living in Australia without a visa and are tried in their country of origin of a criminal offence.